Next case is Ali Bazzi and Genix Physical Therapy Incorporated and Elite Chiropractic Center and Transmedic versus Sentinel Insurance, Citizens Insurance, and Holly Beydoun Bazzi and Miriam Bazzi.
Good morning. May it please the court. Stacey Hanonen on behalf of the plaintiff's appellants. I will waive any limitation on questioning. I might as well get right to it. But I will save 5 minutes for rebuttal. The Court of Appeals opinion in this case must be vacated principally because of its determination that this court's opinion in Titan vitiated coverage for statutorily mandated benefits when an innocent third party has been injured. Rather, what Titan reveals is that the insurer remains responsible to provide statutorily mandated benefits pursuant to a policy it issued, regardless of an insured's fraud when an innocent person is injured. And that's reflected by the fact that the carrier in Titan remained responsible for statutorily mandated $20,000 bodily injury coverage. And this court's recognition in Titan that the remedies available to the insurer may be limited by statute, and as a basis for that cited MCL 500.3009 subpart 1 as providing the coverage minimums.
That's footnote 17 in the Titan opinion, right?
Yes, Your Honor, it is.
Is that footnote consistent with the flow and the body and the text of the rest of the opinion?
Your Honor, I believe it is, and it's providing an example of when a statute limits the remedy of rescission. And specifically, that particular one was identifying the coverage minimums for bodily injury of $20,000, $40,000. And actually, that recognition is even consistent with the court's earlier decision in Keys v. Pace, which quoted Amger stating, as a general rule, apart from a statute, an insurer can avoid the policy if in procuring the insurance, the insured misrepresented a material fact to the risk. So, in effect, what ends up happening here is essentially a partial rescission of the insurance policy. It's not a complete rescission of the document. It's a divisible contract. Because even looking at the deck page here, the declarations page, it sets forth independent charges for each of the coverages that are provided. The optional coverages for collision, theft, coverage, and then the mandatory coverages for bodily injury, $20,000 minimum, and also personal protection insurance benefits. Based on Titan and the statutes that provide coverage, there's statutorily mandate coverage. The only thing that happens is those optional coverages, such as collision, et cetera, those are voided ab initio. The remainder remain intact. And that's the ultimate result from Titan. The carrier's contractual obligation beyond the statutorily mandated $20,000, $40,000 limits was not available for the insureds to recover. Furthermore, pursuant to Titan, the contract must be construed to satisfy relevant provisions of the law. Here, PIP coverage is mandatory to the extent the vehicle is going to be driven on Michigan roads. That's MCL 531.01. And a person is charged with a misdemeanor to the extent that they don't have that coverage in effect. The only time that coverage can be removed or deleted is when the insured states that they're not going to be driving the vehicle on the roads for any particular period of time. And in that case, then the notice has to be sent by the carrier to the insured stating, okay, your PIP coverage is deleted. And that's part of the same statute referenced in footnote 17 of Titan. That's subpart 4 of that statute. One thing that's interesting in Titan is the court's reference to MCL 500.3220, and that's a basis for canceling automobile insurance coverage. That particular statute, as I was going back and reviewing and seeing how they all work together, That statute permits cancellation of bodily injury coverage in certain circumstances. So first, within the initial 55 days of the policy, if the carrier decides the risk is unacceptable, and then also if an insured has, or a user of the vehicle known to the carrier has a suspension or revocation of their driver's license, that becomes final. And that's why the statement in the Financial Responsibility Act at MCL 257.520 F1 becomes important. That states the liability of the insurer becomes absolute when injury or damage occurs, and no fraud of the insured shall constitute a defense. The liability insurance is vindicated in 500.3220. There are opportunities for cancellation. So in looking then at that particular provision of the Financial Responsibility Act, it says, okay, when somebody's injured, you can't even cancel it anymore. There's nothing like that with regard to PIP benefits. When the words of the statute are the most reliable evidence of intent, what we have here is evidence of cancellation is okay in some circumstances. However, rescission is never referenced to be permissible, and the statutes providing for mandatory coverage were determined in Titan to be a basis for limiting equitable remedies. And I did want to point out, too, rescission is an equitable remedy. That's how this court applied it in Titan. So when there are two blameless parties involved, it's important to balance the equities, which should bear the brunt of the ultimate decision. In circumstances that we have here, the insurer at least has a legal remedy to go back against the wrongdoer and sue for damages that they're otherwise required to pay because of the insured's misrepresentations and being obligated to provide statutorily mandated benefits. The innocent person has no such recourse. And to say they're protected by the assigned claims plan, I think, is an oversimplification of it. That is not always the case. And to my understanding, there's another case held in abeyance before the court, Southeastern Michigan Surgical Hospital, where the MACP was not put on notice within the 1 year period of time, and as such, the MACP was not required to pay benefits in that case. And that brings up an important point also, because not only this is the effect that Bazzi has had in practice. Anytime an individual is claiming through somebody else's policy, in order to protect the individual, the MACP is put on notice right away, even if there's not an issue with regard to rescission directly made at that point, just to make sure the MACP has notice and to comply with MCL 500-3145. That in turn creates an obligation on the MACP to open their own file. They'll issue a denial letter right away, as they should, because there appears to be a carrier that's responsible for providing the benefits. As time goes on and it gets closer to the 1 year anniversary of this accident, to the extent benefits are not being paid, then when suit is filed, the MACP is included as a defendant in that suit. And that's also to protect the individual, the injured individual, from losing claims as being barred by the 1 year back rule. So in that case, if rescission has not been accomplished or accepted at that point, the MACP then is filing motions for summary disposition in the trial court saying, we shouldn't be here, there's still a policy at issue. But the fact of the matter is, unless they're brought in, potential claims could be barred by the 1 year back rule. So it's kind of put the whole system as it stands and have it. And
Counsel, can you help me just make sure I understand exactly how that works? So you said when there's an accident, the MACP is notified immediately. Who notifies them? When you said they're notified, who notifies them?
Well, they're notified as soon as possible, and it's through attorneys, to the extent the person has
So a
contacted
competent
attorneys.
attorney should notify the MACP is what you mean? Yeah.
Yes. Whether the individual does, that's probably an even bigger question, because the individual probably doesn't know that they need to protect themselves.
Okay.
So
attorneys are responsible for doing that. It's not, you were, I didn't know if you were saying that for some reason, somehow the insurer who is the primary target would notify the MACP because they want to, make sure there is a backup policy in place in case they win their rescission claim.
From everything I've seen, the insurer does not.
Okay.
It's the individual's attorney to the extent they've retained one. And in many cases, the individual doesn't know to do that themselves.
Okay, got it. Thank you.
You're welcome. Thank you. Unless the panel has any questions, that
I do have one question.
Yes, Your Honor.
As I understand it, in the historical application of equity, there's sometimes a tension in which multiple innocent parties are involved, and a test has arisen to determine among these who is the most innocent. And I think looking at that analysis, at least from my point of view, the traditional approach to answering that question would be that Sentinel, which is also innocent, just as Plaintiff is innocent, Sentinel would probably be the more responsible of the two innocent parties because it set this whole process in motion by selling an insurance policy to Mrs. Bazzi. On the other hand, I guess I'm wondering whether or not that traditional approach to equity is called into question by the fact that the other innocent party, the plaintiff, is a family member who is benefiting from the fraudulent conduct of his own relatives. Can you tell me how we evaluate the comparative or the respectable innocences of the plaintiff with the defendant insurance company?
I'll do my best, Your Honor. At least in this case, there's no indication that Mr. Bazzi was complicit in any type of misrepresentation between family members and Sentinel Insurance Company. So to the extent he's benefiting from anything, it's not of his doing per se. But I think what it comes down to also is in terms of looking at the parties and their abilities to I think what I'm trying to say is to have some other recourse. It does go back to Sentinel because Sentinel can file suit against Mrs. Bazzi for benefits that it is required to pay. So to say that Mr. Bazzi's relatives are getting some sort of benefit themselves, they would not be. Sentinel's action against the Bazzis would be based solely on...
I'm saying the plaintiff, Mr. Bazzi, is garnering some benefit from the fraud engaged by his immediate relatives in this case.
In what I'm trying to respond to is or how I'm trying to respond is the Bazzis get no benefit because Sentinel can go back and sue them for the benefits that they've been required to pay. So it's not like the Bazzis are getting off scot-free.
Well, the only benefit, well, the Bazzis too are getting some benefit in the fact that their son is getting compensation for an injury that he suffered, even though the insurance company that's responsible for paying out that injury is itself an innocent party, just as we assume that the plaintiff is an innocent party, but so is the insurance company.
True, and that's why we're looking at weighing the balances between them.
And I'm asking, in weighing those balances, what weight do we give to the fact that, I mean, in weighing those balances, we're saying, or the common law has tended to say, the insurance company loses because they have set the whole commercial process in motion. But in this case, you have a rather unusual balance that inures in favor of the insurance company of the sort that I just summarized.
No, and that's true, Your Honor, but also to suggest that Mr. Bazzi or his family or any other innocent insured in that circumstance is going to have benefits paid, no issue. I don't think it can be taken that far, because with regard to what we talked about with the MACP may not pay. The MACP may not be obligated to pay based on the one-year back rule, based on notification issues. So, and that's where I think it's important to, again, look at, Sentinel has a legal remedy to go back and collect its potential losses, whereas the innocent individual does not.
Should the rescission equities be weighed as a matter of law, or is that a question of fact for a fact finder?
I think that is a question of fact for the fact finder, because what's equitable in one case may not be necessarily in the next. I mean, in terms of it is, and I think the case law supports it, or as we cited in our brief, that it is on a case-by-case basis.
So some fact finder could conclude that the equities weigh on Sentinel's side instead on the Bazzi side, based on whatever the evidence is.
Based on the evidence, Your Honor.
Or they could say that in this case, as the Chief Justice was saying, Sentinel put this in motion, therefore the equities weigh on the side of the Bazzis. But you think this is a fact question, not a legal question?
I think based on the evidence, I think the ability to use rescission as a benefit and whether it applies in a particular circumstance is based on the facts of the case.
Does it make a difference here that Sentinel has, offered in escrow all the premiums and arguing basically legal rescission? So we're not benefiting any longer because we've returned the premiums.
Well, with regard to the statutorily mandated benefits, Your Honor, I don't believe that's something that they'd be required to return a premium for, because that coverage is not vitiated. And there is a divisible contract where the optional coverages, certainly premiums can be returned for the uninsured motorist benefits. But as to the statutorily mandated, that's something that they'd be able to keep. And I wanted to respond further with regard to equity or rescission being a fact basis. For example, there are cases where the carrier waited more than a year before they made a determination to rescind. So in circumstances like that, it shouldn't apply. So that's what I mean by judging it on a case-by-case basis.
But can't that fact be weighed in the equities in trying to determine whether to permit rescission?
Actually, Your Honor, we've made that argument directly. We have a case exactly like that where the carrier did it. It was dilatory in its investigation. It went way past the one-year anniversary of the accident. And at that time, Bazzi was brand new, so the MACP wasn't even on notice. And at the trial court, what the argument with regard to latches, it fell on deaf ears. That case is now in front of the Court of Appeals.
Okay. You said something before Justice Wilder asked you a question. I just want to follow up on that. You said Sentinel has a remedy, Bazzi does not. What is Sentinel's remedy?
It could go back and sue the wrongdoers.
Why can't
and
Bazzi
recover,
sue the wrongdoers?
Because he had no reliance on those representations. Sentinel's the one who had reliance on the representations. And that's what caused it to issue the policy,
But why
which
didn't
included...
he? Couldn't he say, I believed my mom when she told me that there was a policy? Why? I mean, why isn't that reliance? He's relying on...
Sentinel would not, according to Sentinel, they would not have issued that policy but for those representations. And so I think that's where...
But your answer to Justice R was, Sentinel can sue the wrongdoer.
Can sue the mom, but Bazzi can't sue his mom.
Why can't Bazzi sue his mom?
I mean, to the extent representations were made, there may not be any.
I mean, you mean he may not have any facts to be able to show that he relied on
Right.
his mother saying that there was a policy.
Right.
But then he might be less innocent than, then his innocence claim gets a little tougher, right? I mean, if we're balancing equities.
I suppose when I'm driving my vehicle, I presume it's insured. Or if I'm borrowing somebody's vehicle, I presume it's insured.
Right.
I don't necessarily ask, like, do you have a policy? Is it in effect? There aren't any direct representations made to me. It's a lot of presumptions on my part.
I guess there's a little dirt on those hands then for the application of equity.
No, I don't believe so, Your Honor. I guess because we're looking at who's more innocent between Bazzi and the insurance company. And I don't think just making a presumption is dirt on hands.
Sentinel made a presumption that the application was filled out truthfully.
Yes, they did. And that is...
That's a more dangerous assumption than when you take the keys of someone who loans you their car, that you assume the car is properly insured?
No, I'm not saying that. I'm saying Sentinel's in a better position to have some type of remedy than is Mr. Bazzi or any innocent insured.
Well, if either Sentinel or Plaintiff can sue the mother, it's only because she is the owner, right? And my understanding is that ownership status attaches not merely to that person who may have put down money to purchase the insurance or the car or whatever, but also to somebody who's driven a car for more than 30 days over some period of time. Isn't there some question that maybe the plaintiff himself is an owner of the car?
I don't believe there's any facts in this case.
There's no facts to that?
And that was not an issue below, Your Honor.
But you agree that if he did satisfy whatever that precise test is, I thought it had to do with 30 days having driven the car, that you become, at least for purposes of the No Fault Act, an owner who can be subject to suit here. You would agree hypothetically that he might be able to sue himself, I suppose.
At that point, that is what constructive ownership or how it's determined.
Would that be a fact that would weigh in the reliance or in the rescission interests, his ownership status?
I don't believe so, Your Honor. He's not the titled owner of the vehicle. He's not the registrant of the vehicle. He's borrowing a vehicle in the household. So if he was the titled owner, if he was a registrant, if he was a co-owner, and then he's just leaving it to his mother to go get insurance, then that might be different.
I guess I'm just asking, if you're driving the car more than 30 days, how long can you rely on the presumption that it's insured? And is there any weighing of that? After you drive it for 60 days or 90 days, you should know that it's insured instead of presuming. Just a question. I'm not sure of the answer.
Yeah, I'm not sure. I am not sure of the answer, Your Honor. So unless the panel has any other questions, those are the comments I have, and I'll wait for a rebuttal.
Okay. Thank you very much, Counsel.
Good morning. May it please the Court. Mary Massaran on behalf of the Defendant Appellee Sentinel Insurance Company. With me at counsel table is Joe DiLorenzo. The Court of Appeals correctly held that an insurer is allowed to rescind a fraudulently procured policy, and its opinion should be affirmed for 4 reasons. First, Titan held that an insurer's right to rescind a policy for fraud will be effectuated absent a legislative dictate to alter that right, and none has been identified despite mountains of briefing. Second, no balancing of the equities is required when a contract is deemed void ab initio because of fraud in the procurement of the contract. This is based on fundamental contract formation principles, is a longstanding part of our common law, and should be recognized here. Third, the Court of Appeals decision does not contravene any legislative policy, but effectuates the careful balancing of rights and obligations under the No Fault Act. 257520 does not make coverage absolute upon the happening of an injury or damage in this circumstance, and that conclusion is irrefutable from the discussion in Titan, and in fact is a point that was conceded in the dissenting opinion by Judge Beckering in footnote 24. Permitting rescission also makes sense because unlike the liability coverage under the Motor Vehicle Code, the PIP benefits will likely be covered by other policies in the order of priority or by the Michigan Assigned Claims Plan, and I hope to discuss that more later in terms of the timing. Finally, unless this court affirms, it will seriously unsettle Michigan jurisprudence regarding the interpretation of statutes and contracts and return the state to the confusion existing when statutory interpretation was not tethered to the text, and courts felt free to engraft on new provisions on the basis of policy preferences that were advanced by the parties. Titan applied the now settled interpretive principles to say common law defenses exist unless the legislature says to the contrary. Judge Beckering's dissent, in fact, makes clear in footnote 24 that there is no provision to abrogate common law defenses that applies here, and in fact, she says in her dissenting footnote, it's not a far stretch to see the rationale in analogizing mandatory PIP benefits to mandatory minimum levels of liability coverage. Seems to me that sentence says it all. What is being proposed here is an effort to take a comprehensive statute which has no provision mandating these benefits not be able to be rescinded using a common law, well-established defense on the basis of analogy to a provision that was more limited than that. And that, it seems to me, is inconsistent with Titan, is inconsistent with the last 20 years of this court's jurisprudence, which has sought to clarify and eliminate confusion in the area of both statutory interpretation and contract interpretation. I don't know if I have any more of the free fire zone, but I would waive whatever might remain.
So is that the answer to footnote 17, that the mandatory 2040 is different from PIP and it just simply doesn't transfer? Footnote 17 doesn't transfer. It's not that footnote 17 is dicta or inconsistent with the rest of the Titan opinion, but that there's a huge distinction between PIP and the 2040 mandatory minimums.
I believe that's absolutely true, and I would say two things with respect to that and footnote 17, which I think speaks to 500-3001. First, that section that's referenced there has nothing to say about contract formation. What it's speaking about are what the benefits are in a valid policy. And I think much of the case law is muddled, as it may have been in some of the Court of Appeals decisions, a point also Judge Beckering concedes in her dissent. It's clear, and Rollman talks about this, that there's one line of cases that is talking about if there is a valid policy and there's a dispute about the scope of coverage under that valid policy, then where it's a mandatory coverage, we look to the statute to interpret what the scope of that coverage is. If it's an optional coverage, we look to the language in the contract. That's a whole line of cases. And the position we're urging here is entirely consistent with that. There's another line of cases that deals with whether the policy itself, from its inception, is a valid policy. And in that circumstance, unless there's a legislative dictate saying, no, you can't use that common law defense, even though you would never have issued this policy had you been told the true state of facts when the policy was issued, then you are entitled, as has always been the case under Michigan common law, as far as I'm aware, to rescind that policy, and that goes back to the beginning. That's a basic protection for the integrity of contracting in Michigan, both in the insurance context and in the broader context, and it's one that this court should vindicate in this case.
Ms. Ross, can I suggest why you might be wrong about that? In Titan, optional benefits were at issue. And near the end of Titan, we stated that the remedies available to Titan, quote, may be limited by statute. And in footnote number 17, we discussed in particular the distinction between optional and mandatory benefits. Can't, at least arguably, footnote 17 be understood to suggest that the mandatory minimum coverage required by law constitutes a statutory limitation on an insurer's common law remedy of rescission?
I have a fallback position on that, which I will share with you. I think the position that I just said, which is differentiating, is consistent, entirely consistent with Titan, and I would urge this court to accept it. But there is a different approach, which would also not change the outcome here, but which I think has been discussed, at least in glancing process, in some of the amicus briefs presented on the side of the plaintiff. And that is that 500-3131, which deals with residual liability insurance and talks about, and residual liability insurance, as the court is undoubtedly aware, is insurance for tort liability, not PIP benefits. And what it requires in 3131 is coverage equivalent to that required as evidence of automobile liability insurance under the financial responsibility laws of the place. So what the briefing on the plaintiff's side tried to say was, you can use that language and say, if it has to be equivalent, then with respect to residual liability insurance, you would incorporate 257-520. I think that's one way of reading it. It wouldn't change the outcome here. It's not my preferred position, but I will acknowledge that that would be another way that you could address footnote 17. If you did so, you would still, in my view, have to rule in favor of Bazzi, because what is at issue here is not liability coverage, but PIP coverage. And
that might be one way of reconciling the language doesn't necessarily mean that what I suggested is not an equally or nearly equally reasonable way of interpreting that language. What is your objection to the analysis that I've just suggested about how Titan is not quite as clearly supportive of your position as you've argued?
What Titan says, I think it's a sort of logical step-by-step. So let me walk through, there are not that many steps, but let me walk through the steps, which I think once you walk through those steps, you can't reach a position in favor of the plaintiff here without undermining and conflicting with the holdings and the rationale in Titan. What Titan says is insurance policies are contracts. Therefore, insurance policies as contracts are, insurers can rely on the common law defenses to contracts. Then it goes on to say, however, where the legislature dictates that there should be a different outcome abrogating or modifying those common law defenses, we, the court, of course, will honor that. Then it looks to a particular legislative dictate, 257-520, and it says very carefully, this only applies to Chapter 5, and it goes through the language at great length explaining why that is the case. Chapter 5 is motor vehicle liability insurance. It is not PIP coverage. PIP coverage is in the insurance code. It's not in the motor vehicle code, and it's in a different chapter, not in Chapter 5, but a chapter in the insurance code. Consequently, once you accept those premises, you are left with the question, is there some other legislative dictate that would abrogate the common law defenses? And despite the mountains of briefing that have been presented to this court, no one has identified such a provision. Therefore, it seems to me, just as a matter of irrefutable logic, the outcome has to be what the Court of Appeals concluded. And I would say this as well. We cited in our brief, and various other parties have cited, other instances where the legislature wanted to make an insurance policy incontestable, meaning once certain things have happened, you can't contest it. You couldn't raise a common law defense. You couldn't raise some other kind of defense. The time is gone. It's done that in any number of places in the context of life insurance and annuities, and said after 2 years the policy is incontestable. And we've cited those. So clearly.
But Counsel, good morning. And I'm following your argument incredibly closely. But I think what I'd like to ask you, and first off, it's always a pleasure to have you here in our court. So thank you for joining us today, and Happy New Year. But the question that I would really like to pose to you is that we're dealing with an innocent third party. And what I'd like to do is basically I like to give kind of like a real life scenario to this as to how this case affects real people and how your argument would affect actual real individuals. So what I was thinking about is, I spent the weeks going through the mountains of material that you're talking about, is I thought about my situation would be kind of analogous to a lot of people's situation here in the state of Michigan. So I'm a person that does not have insurance for obvious reasons. I don't drive, which everyone should be thankful for. But here's the question I have for you. And we're just going to use myself as an example. So I'm a person who has to rely on people constantly. I'm always asking people for rides. That's my entire life, is basically waiting for people and requesting transportation and rides from people.
It's true, all the time.
In fact, my colleagues could probably testify to that to the best of anyone. So seeing that Justice McCormick kind of backs me up on my assertion that I'm always asking for rides, which everyone who knows me knows this, what am I supposed to do? I am asking somebody for a ride. I'm not insured. So what do? Am I supposed to, if I'm driving with Justice McCormick, I'm an innocent third party. You were giving this example of all these things that the legislature was talking about, but let's take it back to an innocent third party. What do I do as an innocent third party? I'm getting into the car with somebody. I've asked them for a ride. What is my obligation?
Well, Justice McCormick usually can be trusted not to defraud.
You know what? I want to be honest with you.
You should see insurance costs. Yeah. I have a lot of teenagers.
Well, let me tell you something. I really hope so, because I'm depending on it. So I'm the innocent third party. So what do I do?
Right, and that's an important distinction between the liability provisions and the PIP benefits, because the legislature has provided a remedy. Now, I know plaintiffs
What is my
wait.
What is my remedy? My remedy is
your remedy is the Michigan Assigned Claims
I see.
Plan.
So hold on.
Well, let me,
Let the one great thing about being the justice is I get to ask the question. So that's the one. There's not a lot of perks that come with this job, but this is the one. So let's go back to that. So that's my remedy. But the problem here is that I only have a year in which to do that, correct?
No, that's not correct, and I really would like to address that, because I've been listening to the arguments and I've looked at the briefing, and I think it's a misreading of the clear language of the statute. And I would take this case any day of the week.
Can I go? So how much time? Do I have an unlimited period then to go to the assigned claims?
You have more than enough for any individual or any lawyer to
What do I
make
have?
a
Well,
claim.
what do I
And
have?
it's
I mean, I don't
a
want more than enough. More than we had a
Does it get
case.
like a year from the rescission?
Right. What is the time?
You have, let me walk through, because the timing floats depending on what the insurer, who ultimately may decide not to provide coverage, does. If you look at MCL 500-3174, what it says is a person claiming through the Michigan Automobile Insurance Placement shall notify, that's the obligation, a person shall notify of a claim within the time that would have been allowed for filing an action for PIP benefits if identifiable coverage applicable to the claim had been in effect. So, and then an action has to be commenced within 30 days after receipt of the notice of assignment if you're going to bring suit, or the last day on which the action could have been commenced against an insurer of identifiable coverage, whichever is later. 500-3145 says an action for recovery of PIP benefits, so you have to look at that. Well, how long does the action for recovery of PIP benefits go?
I'm still confused as to how much time I have.
Well,
I'm still at a loss here as to what the answer
Let me
is.
start with an example and go back to the statute, because I can see you really.
Yeah.
Let us say, for example, I am injured.
Okay.
I go to the insurer of the car that I was a passenger in, and I try to get my benefits. And the insurer doesn't give me any answer, says nothing for a year. Okay, so I have that whole year, and I've given my notice to the insurer. I've got injuries. I have that year. The insurer is not doing anything. That might be a clue there's a problem. I probably would notify the Michigan Assigned Claims Plan. But let's say the insurer pays. The insurer pays. Maybe the insurer pays, as in the example that Sister Counsel was proffering, and I don't know that particular case, but let's say the insurer pays for 3 years. And then at the end of that time, the insurer says, oh my gosh, I just realized there was fraud in the inception, too bad for you. You still, under my reading of this, and I think if you look at it carefully, you still would have a year from that time, that is a year from the most recent allowable expense, given the fact that the primary got notice or that the primary was paying. If either of those things happen, then your time is extending. So the specter of
Extended for how long? But extended for how long?
uninsured poor innocent party is a specter without reality, if you read the language. And the legislature was very careful.
But I'm
to
still
do that.
confused. Extended for how long, though? I don't
It
understand.
could be years.
I see. So it's
If you're getting payments, you're injured, you're getting payments, you're getting payments, you're getting payments, it's 20 years now, you've gotten payments, and the insurer comes in and says, whoops, I'm not paying anymore. You have a year
From that date.
That date.
Yeah, so your year doesn't begin to run until you have notice that
Correct.
there's.
Correct.
So that Court of Appeals opinion that holds to the contrary, you would have appealed that if somebody had come to you,
I would have.
and you would have said they deserve to
You know,
actually have
the
the
one
time
that's
extended.
in the record here, and I read that paragraph over and over, trying to figure out what the dates were and what happened. And the factual recitation is not sufficient, in my view, to figure it out entirely. So it's not clear to me if somebody,
There's some other mistake that we're not aware of, or some
right.
other.
what if
In
they
which
haven't?
case you would have an action
What if they
against your lawyer.
haven't? But what if they haven't paid? Like, what if we're going through this period? I'm in litigation, and I haven't received payment, and then they come back and say, oh, we aren't paying because we feel that there was fraud in this. Then what happens?
If you've not received payment and you've not given notice, then as that year is ending, you should know, first of all, there's a problem, and you should then give the notice.
I should. It's
But
my
there's no
response. So it's, wait.
circumstance.
So it's my response. I'm supposed to know this. So it's my. So basically, it's my job to know. Like, I'm an innocent third party, and this is like wholly my responsibility to know that? So if I'm in the middle of litigation, if I basically go to counsel and I'm trying to sort this thing out and figure this thing out, and a year goes by and there's a negotiation going on between the insurance company, and the insurance company is saying, oh, we're looking into this, and oh, we think this is going to be okay, and the adjuster is telling us not to be concerned, and then you're telling me that I get to the end of the year and I haven't done notice with the assigned claims division, that I'm now out of luck, and then I've got a serious catastrophic injury and I'm done?
I'm glad you raised that hypothetical. In the instance where two insurance companies are fighting each other, they both have the obligation to put the Michigan Assigned Claims Plan on notice. The language is the insurer shall, and the person may. So the primary obligation in that circumstance, where there are two insurers who are fighting about who's got priority, they are both supposed to be putting the assigned claims
and if they
provision.
don't?
What if there are not two? There's just one. It's just me. But I gave him this ride. He's
Right.
innocent. I had defrauded my insurance company. And
Way to go. Thanks a lot.
So there's not two people fighting.
Right.
But my insurance company is like investigating because they think I might have, committed some fraud. Do they have to notify the plan? I'm just trying to understand how this works.
No, the language does not say that. In
Right.
that circumstance,
So that's the case where he may be out of luck.
then, well, he would know that he's got a fight within his insurance company.
How would I
not
would
his insurance,
know?
it's my insurance.
Right, it's her
He would
insurance.
know, he would know that he's trying to get benefits and that
And my insurance company
your
is
insurance
obviously
company is
stalling.
not paying.
Right. So he should be able to know.
So he should be able
or
to
his lawyer should
know.
at least.
Well,
Or-
you know when all the health care bills are coming unpaid. and
Exactly.
past due.
Right.
Exactly.
Right.
So I don't think that should serve as a problem, and if anything, the policy considerations weigh more on the side of our position, because another benefit of the Michigan Assigned Claims Plan is it's useful for the system as a whole, and it's useful in two ways. One is it says you aren't going to be successful if you defraud in order to get a policy. That's a cost that is borne across everybody, and the more it happens, the more litigation there is, the more cost there is. And we see in the examples that are before the court how often that happens when someone is trying to save money but get coverage for a child or a friend or a neighbor. That incentive is going to be drastically reduced if the court makes clear that common law defenses apply.
Can I ask a question just to help me? You've helped me a lot to understand how this works. I just need to understand. So if you're correct that the innocent third party is always going to be able to go to the plan, there isn't this timing concern that has been raised in some of the briefing. Just assume that's right for a second. Then help me understand why your client cares, because the way I understand the system is, so your client shouldn't have to. I understand why they wouldn't want to pay when they've been, when fraud has been, committed to get a policy, but to do business in Michigan, they agree to take some market share from the plan, right? So they win. So they don't have to pay Justice Bernstein in my case. But tomorrow, Justice Zara is going to go to the plan because the Chief Justice has defrauded his insurance company as well. And when he goes to the plan, Sentinel's going to get stuck paying for Justice Zara. So I don't know, why do they care? Why does your client care?
Two reasons, both of them very important. One of them is insurers do not want to be issuing policies on the basis of fraud. That's just a fundamental question of the integrity of the system. That's very important to anybody who's contracting.
But that doesn't answer why we wouldn't balance the equities. Because if someone's going to pay no matter what, why?
Secondly, if those claims go to the Michigan Assigned Claims Plan, and one of the amicus briefs runs through this at great length. I'm blanking on which one right now, but there are cost containment provisions in the Michigan Assigned Claims Plan, and in addition, the Michigan Assigned Claims Plan says, for example, if there's an alternate source of coverage, your personal health insurance, for example, or other collateral sources, those pay first, and collectively the industry and all of us
So when you
pay
get assigned
second.
the case through the plan, you have more flexibility in deferring, in taking your costs down. I get it. That makes
Correct.
sense.
But
Got it.
doesn't this, and I'm just, and help me to understand this, doesn't this encourage a certain level of gamesmanship on the part of the insurance company? Like, doesn't it kind of incentivize them to kind of, not come forward, to hold back, to wait, to, isn't there a certain incentive for them to do the investigation after the date? Like, isn't there a certain, can't this result in some little nefarious kind of conduct in the sense of, that they can basically be incentivized to kind of hold back, to wait, to basically say, oh, guess what, we found a mistake in the policy, and basically you could probably find a lot of mistakes in a lot of policies, and doesn't it just kind of give them this kind of idea that we should do this later rather than earlier?
I don't believe it does. I understand the point that the question is going toward, because I think what it says is fraud in the system is not going to be tolerated. That's number one. And as the court said in Titan, the insurer is not obligated to view every
But wait, hold
customer.
on. If fraud is not, if fraud is not going to be tolerated, shouldn't you know that there's fraud sooner rather than later? I mean, basically, you're saying that fraud is not entitled, but the insurance company is still taking the claim. They're still taking the money. They're still taking the people's money, and then they're saying, oh, there's fraud. Oh my God, there's fraud. And they're finding the fraud later. The question here is that shouldn't we incentivize it the other way? That basically it's the insurance company's responsibility to make sure that the insurance is adjudicated appropriately in the beginning, rather than basically have this ability to kind of come at it at the back end and say, well, we've been taking your money, but now we're not going to pay because we found this inconsistency.
I think Titan addressed and resolved that question when Titan said you could always investigate further at the outset to try to figure out whether the person who's coming to purchase your policy is being an honest and upright person. But that is an endless stream of inquiry, a costly endless stream of inquiry, and the insurer should not be placed at the burden of having that.
I think, though, the insurance company seems to be doing pretty well under this, because basically, if I'm the insurance company, my incentive is to basically take your money, to basically say, all right, well, I'm gonna start start charging you those premiums, and then under your plan here, under your argument, my incentive is to wait until now a claim is filed and then say, oh, there is some fraud here. Oh my goodness, just like, they're basically going to say after a claim is filed, when now they have to actually start paying back, they're going to say, wow, look at this, there's fraud, and we don't have to pay. So, I mean, your argument, help me to understand this. I mean, basically, aren't they basically getting the windfall here by basically saying that it's really not up to us to investigate until we have to pay, and then we have this benefit of when we have to pay, being able to say, oh my God, we don't have to. We found this fraud. Why is it not their responsibility to do this in the beginning before they start accepting the premiums?
There isn't, first of all, there isn't any statutory mandate about the specific inquiries. Second, most insurance companies have robust systems to try to make sure that they're getting accurate information. However, as this court said in Titan, we aren't going to hold them to some endless stream of inquiry after which we're going to assume common law defenses don't apply, because we are not going to assume that everybody who goes in to purchase a policy is a person who is lying to them about material information.
But when a claim is filed, then isn't that when they start doing their fraud inspection? Like, once a claim is filed, isn't that when they start saying, oh, let's do a fraud investigation? Well, isn't that trigger, as soon as you file a claim with your insurance company, isn't that then the trigger point for them to say, let's see if there's fraud, and let's see if we can make a case for it?
Well, I haven't filed that many claims, but when I have, I don't think they've resulted in a fraud investigation. However, sometimes in the course of litigation, after an accident, information does become available that makes clear that there was fraud in the inception. And under this court's decision in Titan and the past 2 decades of contract and insurance cases, it seems to me the answer here is for an affirmance, which is what I would ask of the court.
What is your, go ahead.
Before you go, I wanted to try to get in on the action too. So the question, your position is that the common law defenses were not abrogated, so your client could ask for and seek rescission. But then you take the position that there should be no balancing of equities. So you're not really asking for the entirety of equitable relief in the way that courts of equity have administered that relief for, centuries. You're asking, I guess, am I wrong to interpret you're asking for some sort of partial abrogation of the common law to just get the defense that you want, but not all of it? So it seems to me, are you taking your cake and eating it too, or am I wrong?
I don't believe I am, but I do think historically in this situation where a contract has been entered into on the basis of material fraudulent representations that would have prevented that contract from ever being issued, the courts have routinely said that is what we look at, and the results of that is pretty much a per se rule that the contract is rescinded.
Conclusion, the court doesn't, you're telling me there was no rescission?
There's not.
No rescission cases in history involving contract formation where the court has balanced the equities? That's
I'm not going to
position?
say no rescission cases in history. That's quite broad.
Well, show me what are the cases that support your view of this modified abrogation?
And that was my question.
If you look at
What are the cases?
if you look at the cases where the courts are balancing, they are typically cases where it's like a land contract. They're not cases that are arising in this context. I did not find any.
Or else you wouldn't be here. But you cited a case in your brief, I think Stokes, where Justice Markman wrote an opinion indicating that the equitable principles we wouldn't apply those if they conflicted with a statute. But it just seems to me, again, you're sort of wanting your cake and eating it too, because you're saying the statute doesn't prevent us from applying equitable defenses, but it somehow does prevent us from balancing the equities when we're applying the very defenses that your client would have us apply in this case.
Let me say 2 things. One is, I don't believe that the equitable defense of rescission is subject to a case-by-case jury trial. I think that would be a recipe for disaster. No one would know what the law would be. It would be inconsistent.
I just speak out that I agree with you that equitable questions are decided by a court of equity. I mean, I guess the court could ask for an advisory jury to decide some factual issues if you want to get very technical, but ultimately those questions will be left to the court.
And with respect to the equities between the innocent insurer, which issued a policy on the basis of fraudulent statements, I would say you would look to the point at which the contract was issued, and you would say you have an innocent party on one side and a defrauding party on the other. You don't go 5 years, 10 years down the road and say, okay, now we have this information, this accident that has come after, unless, as in 57520, the legislature says we're going to make it incontestable, or we're going to say once an injury has happened, you can't. What I'm saying is the traditional approach of applying the equitable defense of rescission in this circumstance where there's been fraud in the procurement is to look at the insurer and the insured and to say the contract is abrogated ab initio, and that's the end of the story.
Do you have a case from this court that says that? Do you have a case from this court that says that?
This may be the case where you could say that.
She's giving us that opportunity.
You're not taking the position that if the proofs establish that the insurer actually knew of the fraud and continued to take premiums, and then when there's a claim made, attempts to rescind, that the court wouldn't have the power and equity to say, no, there's no rescission there.
No, I'm not. I'm not pushing it that far, and I think that would not be the correct result.
Okay, are there any further questions?
No.
Okay, thank you, Ms. Masseron. Counsel, you have 5 minutes to go.
Thank you, Your Honor. Actually, my initial comment is, in this case, why wouldn't you consider the innocent insured as somebody whose interests need to be taken into account in balancing the equities? This is the individual who stands to lose benefits, as you indicated, Justice Bernstein, as an employee or a babysitter. I mean, not necessarily just a family member in this particular context. And that leads into this idea that timing floats in terms of being able to go to the MACP. Timing's limited, and that starts off with notice to the MACP initially. Counsel's arguments do not take into context situations where, yes, the issuing insurer is making payments, and at some point during the claim identifies information that leads it to investigate fraud, and that could be towards the end of the 1 year period to give notice to the MACP, or even after, because there's no time limit here. And to
You disagree with her characterization that if payments stop, there's 1 year from that time?
To commence suit, but the notice to the MACP
There's
originally.
no time to commence notice after that?
Notice is linked with 3145, which is, so it's the person claiming through the assigned claims plan shall notify the Michigan Automobile Insurance Placement Facility within the time that would have been allowed for filing an action for personal protection benefits if identifiable coverage to the claim had been in effect. So that also includes, notifying within the 1 year. In terms of the MACP itself, it's supposed to be the insurer of last resort. The benefits at issue here are mandated by statute. There's a particular carrier to go to in this case, the insurer of the owner or registrant of the vehicle occupied for purposes of statutorily mandated benefits. In that regard, the Court of Appeals that erred when it determined that Titan versus Heighton abrogated the innocent insured rule with regard to statutorily mandated benefits. And as such, it should be vacated. And the trial court's order denying summary disposition reinstated. So does the panel have any more questions?
Thank you, Counsel.
Okay, thank you.
Case will be submitted.